I had exactly $412.67 in my checking account, a healing incision under my sweatshirt, a 7-week-old baby asleep in a borrowed carrier, and a sealed USB drive taped inside a sympathy card when my husband's older sister told me, in front of the funeral flowers, that I was no longer welcome in my own house. She said it quietly, which somehow made it worse. Not angry, not loud, just efficient. Once probate opens, she said, smoothing the front of her black dress like she was straightening office paperwork instead of erasing a widow, the company comes back to family. The house, too. You and the baby will need to make arrangements. Her name was Claire Mercer. She was 42, polished, precise, and had spent the last 10 years introducing herself at charity events as the silent force behind my husband's success, even though the only thing she'd ever built herself was a reputation for arriving after the hard part was done. My husband was Daniel Mercer, 38, founder of a mid-sized commercial design firm in Savannah, Georgia, the kind of firm that did courthouse renovations, boutique hotels, and expensive waterfront projects for people who liked the word legacy more than they liked paying invoices on time. He died on a Monday in early September when a truck crossed the center line outside Pooler and hit his car broadside on the way back from a client meeting. I was still recovering from an emergency C-section. Our son, Owen, had been in the NICU for 12 days. By the time Daniel died, I had barely slept in a month. My body felt stitched together in a hurry. I was moving carefully, thinking slowly, signing whatever the hospital billing department put in front of me because numbers had started looking like weather to me. Just conditions passing through. At the visitation, Claire stood near the front with Daniel's college friend Russ Kendall, who had been the firm's outside CFO consultant for years and had recently started acting like he belonged in every room Daniel used to occupy. Russ wore one of those dark blue suits men buy when they want to look respectable enough to say alarming things. He kept a hand on Claire's elbow the whole evening, not romantic exactly, but proprietary in a way that made me notice. I remember Owen stirring against my chest. I remember the smell of lilies. I remember Claire leaning slightly closer and saying, "Daniel should have planned this better." That was the moment I understood grief had company. 2 days later, a courier brought a packet to the house on Whitaker Street. Claire had filed an emergency petition in Chatham County Probate Court challenging Daniel's estate plan. She claimed Daniel lacked capacity when he updated it after Owen was born. Russ signed an affidavit claiming the firm was in material distress and required immediate control by experienced hands to preserve value. Claire also asserted that the historic townhouse we lived in had been substantially maintained using family money from a temporary advance her father made years earlier, which she now characterized as an ownership interest. It was elegant in the ugliest possible way. Not a scream. A filing. My attorney, Marlene Price, read the packet in my kitchen while I stood at the counter pumping breast milk and trying not to faint from exhaustion. Marlene was in her late 50s, wore soft gray suits and reading glasses on a chain, and had that rare lawyer quality of sounding calmer the worse things got. She said, "If you miss this, you lose everything." Then she set the pages down and looked at me over the rims of her glasses. "I need you awake for the next sentence. Claire is trying to take temporary control of Mercer Atelier before we can lock down the records. If she gets access first, she can scare vendors, spook clients, and turn confusion into evidence. We fight now, or we spend a year cleaning up the smoke." I should have said yes immediately. Instead, I looked at Owen's diaper bag on the chair, at the stack of casseroles people had dropped off, at the half-folded baby laundry on my sofa, and I said, "Can I have one night?" Marlene didn't like that answer, but she gave it to me. That evening, after she left, my mother came down from Columbia and asked the kind of question only mothers ask when they know the answer but want to hear whether you still do. "Did Daniel trust you?" "Yes." "Then act like it." It would have been a clean, simple story if Claire had only become cruel after Daniel died. But cruelty like hers usually has an earlier draft. The first time I met Claire, Daniel and I had been dating 6 months. We were at a family lunch on Isle of Hope. I was 28, working as a project coordinator for a preservation nonprofit, still paying off graduate school, and wearing a linen dress I'd ironed twice because I wanted to seem steadier than I felt. Claire asked where I lived. I told her I rented a duplex on the east side. She smiled into her iced tea and said, "Oh, good. So if this doesn't work out, no real estate complications." Daniel heard her. He went still. Then he said, very quietly, if what doesn't work out? Claire never apologized. She just reached for the deviled eggs and began asking someone else about a fundraiser as if she hadn't laid a little blade on the table. The second incident came 3 years later, after Daniel and I married. At Thanksgiving, Claire introduced me to a donor from one of her museum committees as Daniel's administrative miracle. I said I run external partnerships for the Preservation Trust. Claire smiled and replied, "That sounds prettier than assistant." Smart. The donor looked embarrassed for me. Daniel left the room. In the car home, I told him not to make a family war out of one sentence. He gripped the steering wheel and said, "That's how she wins. She says it sweetly enough that everyone else feels rude if they name it." He knew her. He just never believed she would come for blood. Around 9 that night, after feeding Owen, I finally opened the sympathy cards still stacked on the dining table. Most were what you'd expect. Bible verses, mass cards, handwriting made trembly by genuine sadness. Then I found one with no signature inside, only a printed line, for when silence becomes expensive. Something stiff was taped into the fold. A small black USB drive. I sat down very slowly. The attached note had one sentence, typed no name. Check the board folder first. Daniel's laptop was still in his home office upstairs. I hadn't gone in since the day the police officer brought it back in an evidence bag with his watch and wallet. The room still smelled like cedar and printer ink. His desk was too neat because he had always cleaned it before bed, even after 14-hour days. I plugged in the USB. It contained 4 folders: board, insurance, harbor, metadata. The first folder changed everything. Mercer Atelier was not Daniel alone. 6 months before Owen was born, Daniel had reorganized the business structure after a dispute with Claire over succession and informal family oversight. There was a signed operating agreement for a parent LLC, one I had never seen. Daniel owned 51%. A trust held 34% for Owen. The remaining 15% belonged to a silent early investor who had never interfered. More importantly, Daniel had written a triggering clause into the succession documents. If anyone challenged the trust's validity using fabricated internal records, the challenging party could be barred from any discretionary family distributions tied to a separate real estate holding company their late father had created. At first, I did not understand what I was reading. Then I found Daniel's annotation in the margin of a scanned draft. In that narrow, tidy handwriting of his, Claire will call anything family property if no one stops her in writing. So I did. The second folder held copies of his updated life insurance, retirement accounts, and a transfer on death brokerage account. All direct beneficiary designations. All outside probate. All in my name or Owen's trust. The third folder, Harbor, contained invoices, emails, and draft change orders involving a riverfront hotel project Russ had managed on the finance side. There were cost overruns, double-billed consultant hours, and one alarming chain where Russ asked Daniel to move a payment date so a lender compliance review would look cleaner. Daniel had refused. The fourth folder, Metadata, was full of exported emails, file histories, and a spreadsheet mapping document creation times, edits, and user access logs. Not dramatic looking, just rows of dates and names. The kind of thing most people ignore until it becomes a knife. At 11:14 p.m., I found the thing that made me put my hand over my mouth. A set of board minutes Claire had attached to her court filing, minutes supposedly authorizing temporary operational control to her in the event Daniel became incapacitated, had not existed on the dates shown. The metadata trail on Daniel's server export showed the file had been created 3 days after his funeral from Russ's office login, then backdated in the PDF properties. Not suspicion. Not instinct. Metadata. I called Marlene at 11:32. She answered on the third ring, sounding fully awake, which is how you know a lawyer has seen enough of life. "I found something," I said. She listened for 6 minutes without interrupting me once. Then she said, "Good. Bring diapers. We're going to war." By morning, Marlene had a forensic e-discovery specialist lined up and a motion drafted to preserve all corporate and server records. She also had a warning for me. "This isn't revenge. This is justice." I nodded, but the truth was more complicated. Justice is clean in speeches. In real life, it arrives carrying grief, milk stains, legal pads, and the memory of someone telling you your baby could stay, but your life had to go. Claire escalated before court did. She sent 2 employees to the house with printed inventory sheets, claiming they needed to secure company-owned furnishings because Daniel had occasionally stored presentation boards and fabric books in the downstairs library. They stepped onto my porch with clipboards and the confidence of people who thought a widow recovering from surgery would be too tired to object. I opened the door holding Owen. I said, "Leave." One of them, a junior designer named Madeline, looked mortified. The other glanced at his paper and said, "Ms. Mercer authorized us to tag office property." I said, "Then Ms. Mercer can explain that to my attorney." Madeline whispered, "I'm sorry," before they left. I remembered that. The next day, Claire called one of Daniel's longtime clients, a hotel owner named Brent Salazar, and told him I was emotionally unstable, that documents might disappear, that he should reroute all future communications through her. Brent did not reroute them. Instead, he forwarded the email to Marlene with the subject line, "This feels like a hostage note in pearls. Good clients are a blessing. Great clients are witnesses." By Friday, the probate hearing on temporary control had been moved up because Claire's lawyer argued operational urgency. Only it would not be at the usual courtroom downtown. A plumbing failure on the probate floor forced an emergency venue switched to a larger civil courtroom 2 buildings over. A small detail. A location twist. The kind that matters because bigger rooms hold more people, and more people hear things they weren't meant to. Marlene smiled when she heard. "Crowded is good," she said. On the morning of the hearing, I wore the only black dress that still fit my post-surgery body and flats because my balance still felt unreliable. My scar tugged when I walked too fast. I hated that. I hated all the small ways loss had made me careful. Claire entered with Russ and her attorney, Peter Whalen, who specialized in business injunctions and had the polished expression of a man accustomed to charging for panic. Russ carried a banker's box. Claire did not look at me. That was deliberate. People like her save eye contact for equals. The courtroom filled more than expected. Staff. A few clients. 2 reporters from local business outlets because someone had leaked that a prominent Savannah design firm was in a succession dispute. Brent Salazar sat in the back row. So did Madeline, the junior designer, looking like she'd barely slept. When the hearing started, Peter framed it exactly as Marlene predicted. Young widow, tragic circumstances, urgent company risk, older sister stepping in to preserve jobs and value. He introduced the board minutes. He introduced Russ's affidavit. He used the phrase fiduciary necessity twice, which is how lawyers say ambition in a necktie. Then Marlene stood. Her voice was almost disappointingly calm. She did not argue first. She asked for the court's permission to address authenticity. She handed up certified copies of the operating agreement, trust schedules, and beneficiary confirmations. She established that Claire had no automatic controlling interest. She established that core assets outside probate were not part of the estate fight no matter how loudly someone wished otherwise. Then she asked the judge to consider whether the emergency petition itself had been built on fabricated records. Peter objected. Of course he did. The judge allowed limited inquiry. Marlene called the forensic specialist first, a compact woman named Elena Baird who explained metadata the way good teachers explain weather patterns. Not too much. Just enough. She walked through server logs, creation dates, user credentials, and edit histories. She explained that while PDF visible dates can be manipulated, underlying system logs tied to server exports are much harder to fake. She pointed to the board minutes Claire relied on and said, This file was not present on the company server on the date represented. It appears to have been created later from credentials assigned to Mr. Kendall. The courtroom did not go theatrical. Real silence is better than gasps. It is heavier. Peter tried to rehabilitate Russ by suggesting routine administrative cleanup, later scanning innocent discrepancies. Elena stayed patient. Then Marlene introduced the underlying email chain from months earlier showing Daniel explicitly rejecting Claire's request for temporary authority language in succession documents. Peter's face changed first, then Claire's. Russ looked at the table. Marlene was not finished. She called Brent Salazar, the client Claire had contacted. He testified that Claire attempted to interfere with active business relationships by implying I was unstable and records were at risk. Then, unexpectedly, Marlene called Madeline. That was the ally twist. Madeline was not there for curiosity. She had come because 2 nights earlier she found an exported email in a shared archive Claire and Russ overlooked while trying to clean up the transition folder. In it, Russ wrote to Claire after Daniel's funeral, "If she folds fast, nobody will audit Harbor. We just need temporary control on paper." Madeline had forwarded it to herself, then to Marlene. On the stand, voice shaking but clear, she authenticated the archive and testified that Russ instructed staff not to speak with me directly because, in his words, widows get sentimental and make expensive delays. The judge removed his glasses. That is a small gesture, but in a courtroom it can feel like thunder. Peter asked for a recess. The judge denied it. Then Marlene made the move Daniel had prepared for without ever telling me the whole shape of it. She introduced the fraud carve-out language from the family holding company tied to the Mercer warehouse properties Claire still drew distributions from. It did not decide ownership that day, but it was enough to show the court that if Claire had knowingly advanced falsified governance documents to seize company control, her actions could trigger separate financial consequences far larger than this probate fight. For the first time, Claire looked at me directly. There was no grief in her face then, only calculation discovering it had mispriced the room. The courtroom went silent when the judge said, "I am not granting emergency control to a petitioner relying on records of disputed authenticity. I am entering a preservation order, appointing a neutral temporary administrator for the firm's operations, and referring the questioned documents for further review." He paused. Then he added, "No one is to remove, destroy, or alter any company records, devices, or accounts. Not one email." Russ closed his eyes. Claire sat perfectly still, like a woman trying not to move inside a photograph. When we stepped into the hallway, Peter was already speaking to Claire in a tone that meant his hourly rate had just become painful. Reporters drifted closer. Cameras did not swarm. Savannah isn't New York. But in a city built on architecture, money, and memory, people notice when a respected family starts bleeding in public. Marlene touched my elbow and said, "Do not speak." So I didn't. I put the phone face down. Then I waited. Part 2 waiting turned out to be the most expensive thing Claire had ever done. Once the neutral administrator took control of Mercer Atelier, the rest stopped being a family argument and became what Claire should have feared from the beginning, a paper trail with no reason to protect her. Within 2 weeks, the administrator found irregularities in the Harbor House Hotel project Russell Kendall had managed. Not cinematic theft. Nothing with offshore islands or fake passports. Just the kind of white-collar misconduct that ruins people slowly and thoroughly. Inflated consulting pass-throughs. Reclassified payments. Timing manipulations designed to satisfy lender covenants before quarter close. The sort of fraud men like Russ commit because they believe spreadsheets are quieter than guns. The lender opened its own review. The hotel owner hired separate counsel. Russ retained a criminal defense attorney before the month was out. Claire still could have minimized the damage then. She could have withdrawn the probate challenge, blamed Russ, apologized to the court, and preserved some sliver of dignity. Instead, she doubled down in the only language she trusted, entitlement dressed as certainty. She filed an amended petition arguing that, forged or not, the board minutes merely reflected Daniel's true wishes, a phrase so legally weak it sounded embarrassed while being typed. She also began telling anyone who would listen that I had manipulated Daniel after childbirth. That medication had clouded his judgment when he updated beneficiaries and trust documents. When Marlene read that paragraph aloud to me in her office, I laughed. Not because it was funny, because it was tired. Women like Claire always arrive at the same theory eventually. If a younger woman ends up with the money, she must have tricked a man into his own signature. Marlene filed a response attaching Daniel's physician affidavit regarding competency. The notarized estate updates and a timeline showing his revisions were completed over several appointments, not in one emotional blur. She also added something extra: a request for fees. That got Claire's attention. The next public turning point came at a case management conference 6 weeks later. It wasn't supposed to be dramatic. Those hearings usually involve scheduling, discovery deadlines, maybe a little procedural chest thumping. But public humiliation doesn't always send a calendar invitation. The conference room on the second floor was packed because by then word had spread. Business reporters, 2 local attorneys who had no role in the case and every intention of pretending otherwise. A donor from Claire's museum board, Brent Salazar again. Even one of Claire's old dry cleaning managers, which told me small-town loyalty was beginning to fray. Peter Whalen was gone. Claire had replaced him with a sharper, colder litigator from Atlanta named Janice Hall, who took one look at the record and tried to build the only bridge available, narrow the issue, isolate Claire from Russ, and argue that Claire reasonably relied on documents presented to her. It might have worked, except Russ had started cooperating. Not fully, not nobly. Men like Russ rarely discover conscience before subpoenas. But pressure is its own teacher. Once the lender's lawyers cornered him with invoices and email headers, he began carefully repositioning himself as a financial advisor swept up by a grieving sister's urgency. Janice knew this and hated it. At the conference, Marlene produced a stipulation draft from Russ's counsel acknowledging that Claire had requested something formal to show the court because, as one text put it, widow tears are winning the sympathy race. Janice objected to characterization. The judge overruled her long enough to read the text himself. The room changed temperature. Claire, who had spent 2 months presenting herself as the responsible adult in a room full of emotional people, now looked exactly what she was, a woman who mistook control for character. Then came the sentence that broke her public standing. The judge said, "Ms. Mercer, this court is increasingly concerned that your filings were not merely aggressive, but knowingly misleading." He did not raise his voice. He did not need to. The museum donor in the back row stared at Claire as if seeing her for the first time. That afternoon, one of the local outlets ran the headline, "Probate Judge Questions Authenticity in Mercer's Succession Fight Not Devastating by National Standards." Devastating in Savannah. Invitations began disappearing. Board renewals got deferred. People who once enjoyed Claire's certainty developed urgent scheduling conflicts. Meanwhile, actual life continued, which is one of grief's strangest habits. Even when courts are sorting your name into paragraphs, your son still needs formula, baths, vaccines, lullabies. Owen developed a stubborn preference for falling asleep only if I paced the apartment and hummed badly. I became very familiar with 2 a.m. shadows and one-handed bottle prep. I also became, without asking anyone's permission, financially harder to scare. Daniel's insurance proceeds had already cleared. The brokerage transfer settled cleanly. The trust for Owen was funded. I leased a modest office suite with exposed brick and terrible parking for the preservation consulting practice I had quietly started rebuilding on my own. No grand launch. No inspirational speeches. Just contracts, deadlines, and work. My flaw, the one Daniel used to identify with infuriating accuracy, was hesitation. I overprocessed. I waited too long to believe my own read of a room. That flaw cost me early in the fight. I almost gave Claire the advantage because grief made me confuse silence with safety. I did not make that mistake again. 3 months into discovery, Marlene took Claire's deposition. I was allowed to attend but not speak. Depositions are dull until they become brutal. This one became brutal around page 73. Claire arrived in cream wool despite the Georgia heat, carrying herself with a thin, polished dignity of someone still hoping clothing can reverse evidence. Janice sat beside her. A court reporter adjusted her machine. Marlene began gently, almost kindly, walking through family relationships, business involvement, and the origin of the supposed board minutes. Claire claimed she believed the records were valid. Marlene handed her the text chain with Russ. Claire said she had been frustrated and using shorthand. Marlene handed her Daniel's earlier email rejecting temporary authority language. Claire said Daniel often changed his mind verbally. Marlene asked for dates, witnesses, follow-up emails, anything. There was nothing. Then Marlene brought out the operating agreement and the canary-style fraud carve-out tied to the warehouse holding company. She asked Claire whether she had reviewed that clause before filing. Claire said no. Marlene asked whether she understood that if her petition relied on fabricated records, her own distributions from the family company could be suspended pending civil review. Claire blinked twice. Janice objected to form. Marlene let the objection sit there like bad perfume and asked the question again in a narrower way. Claire answered, "No one explained that to me." Marlene said, "Your lawyers or your brother's late husband?" Claire went quiet. It was the first honest thing she'd done in months. After the deposition, Janice asked for a private conference with Marlene. I waited in the hallway by a water cooler that tasted faintly of metal. 20 minutes later, Marlene emerged, tucked her notes into her bag, and said they want to discuss settlement. I looked through the glass panel in the conference room door and saw Claire sitting very still, staring at the table. "What kind?" I asked. Marlene's mouth shifted, not quite a smile. "The expensive kind." The final negotiations happened in January, in mediation first, and then back before the judge for approval of a stipulated resolution. By then, Russ had agreed to cooperate in separate civil claims involving the harbor project. The lender was pursuing him. The hotel owner was pursuing him. And Janice, who had inherited Claire's disaster after the good exits were already blocked, was trying to keep her client from becoming a cautionary seminar topic for every probate attorney in coastal Georgia. The deal Marlene extracted was not loud. The best outcomes rarely are. Claire withdrew all estate challenges with prejudice, meaning she could not refile them. She acknowledged that the questioned board minutes would not be relied upon in any future proceeding. She agreed to pay a significant portion of my attorney's fees. She accepted a permanent no-contact provision regarding Owen outside of narrowly defined written communication routed through counsel for family medical emergencies only. The neutral administrator's findings supported a separate removal of Claire from any attempted governance role in Mercer Atelier. And because discovery had shown enough to raise serious concerns under the warehouse holding company clause, Claire also agreed to a private restructuring that froze her discretionary distributions for a review period and forced disclosure of prior family transfers she had spent years treating like invisible entitlement. In plain English, the money stopped gliding toward her. That hurt more than any speech. The judge approved the agreement in a short hearing on a rainy Thursday. Claire did not look at me when she signed. Janice did all the talking. Russ was not present. He had moved from polished advisor to cautionary footnote in under 6 months. As we left, Marlene squeezed my shoulder once and said, "You know what saved you?" "Daniel?" "Documents," she said. Daniel helped. But documents save people from the stories other people try to tell about them. Outside the courthouse, the square smelled like wet brick and old trees. I stood under the awning for a moment longer than necessary because the rain gave me an excuse not to rush into the next thing. For months, every day had carried a filing deadline, a pumping schedule, a call from counsel, a fresh insult disguised as procedure. And suddenly there was space. Not joy exactly. Space. The last time Claire called me was 3 weeks later from a number I did not recognize. Against my better judgment, I answered. Her voice sounded older, not softer, just stripped. She said I made mistakes. I said nothing. She tried again. Russ lied to me. That one almost worked. Not because I believed it, but because it was so carefully calibrated. Just enough truth to make room for the lie she preferred most, that she had merely followed the wrong man instead of choosing the wrong thing. Finally, I said, "You stood in my hallway while my son was 7 weeks old and told me the house mattered more than the baby. I have no use for your revisions now." She started crying then. Real crying this time, I think. I did not comfort her. I said, "Do not call me again." Then I ended it. I put the phone face down. Then I made Owen's bottle. 1 year later, I owned a small but busy preservation consulting firm with 4 employees and a waiting list long enough to make me finally hire the office manager I had resisted because part of me still thought self-sufficiency had to look exhausting to count. Owen was walking, badly and with enormous confidence, which felt like an appropriate family trait. On Saturdays, we went to Forsyth Park early before it got crowded. He liked the fountain and pigeons and had recently developed a deep personal attachment to blueberries. I kept one framed photo of Daniel in my office, not as a shrine, just as continuity. Some losses become less sharp without becoming smaller. Mercer Ateliers survived too, under new management and with fewer people trying to convert grief into leverage. Brent stayed on as a client. Madeline got promoted. Marlene sent me Christmas cards with 2 lines of handwriting and impeccable punctuation. As for Claire, consequences arrived in the plain clothes they usually prefer. 2 museum boards quietly rotated her off. One of the warehouse reviews ended in a buyout structure far less generous than what she'd once considered her birthright. She sold the family house on Isle of Hope the following summer. Not because she had to starve. Because pride costs money, and hers had started charging interest. None of that brought Daniel back. That is the part weak stories get wrong. Justice is not resurrection. It does not return the dead or refund the nights you spend standing in a dark kitchen trying to remember how your life used to sound. What it does, if you are lucky and prepared and willing to stop apologizing for defending yourself, is restore order. It tells the truth in a room where lies arrived overdressed. It puts weight back where it belongs. Daniel gave me evidence. Marlene gave me structure. But the boundary itself, that part was mine. And if there is a lesson in all this, it is not that every villain will collapse spectacularly in public. Some do. Most simply run out of places to hide one's records, witnesses, and patience line up in the same direction. The louder lesson is quieter. When someone treats your grief like an opening, believe them the first time. Then answer with documents, discipline, and a door they cannot walk back through. So tell me, what would you have done the moment Claire said she wanted everything but the child? And if you stayed with me through this one, subscribe, because sometimes the calmest stories carry the sharpest endings.